Good afternoon, folks. Alex Woods here, litigator with Redwood Legal. Now, this is an issue that has come up quite a lot recently, and I've actually lost business because my clients were a little bit nervous about what might happen if they lost a claim against an estate. Now, I'm going to come on to, hopefully by the conclusion of this vlog, reassure you not to be too concerned about the danger of costs and the danger of having to pay the other side's legal bill if you lose, where you are contesting a will or making an Inheritance Act claim. Okay, so I'll just give you a flavour of the sorts of cases that I'm talking about, and these are all based on cases that we've either run or we are running. One would be a cohabitant, a romantic partner who's not married the deceased but lived with them longer than 2 years. Perhaps the will has left everything to, other relatives, or just they've died intestate and she's not entitled to a claim because she's not married to the chap. So that would be one example. Another example is where you have, I think of an example where you've got a sister who's actually disabled, pretty poor, father dies and the other siblings get all the money. I mean, that's classic Inheritance Act claim territory. Then got another case quite interesting, which is more about proprietary estoppel, where basically the deceased during their lifetime was looked after and said to the, in this case, the sibling that was looking after them, don't worry, I know I'm putting you to a lot of bother by having to look after me, particularly if the party's been hospitalised and medical treatment, and just basically you're looking after an old person. I'll look after you in my will. So that's another example. So you get the flavour of the types of cases that often occur in where will disputes and Inheritance Act claims are concerned. Now here's the rub. You may feel you fall into one of those categories. I should just actually add one further category, which is a client who's an only child of the deceased who never remarried, and she's not particularly well heeled. And my view of that case is that she's entitled to a substantial payout. So my preliminary view of that case. So you've got these typical categories of cases in the area of wills and Inheritance Act disputes. Watch other vlogs for what the Inheritance Act is, incidentally, if you're interested. So there you are. You're thinking, well, I think I fall into one of these categories. I know it's often a big decision to challenge the will of a deceased. You feel a bit uncomfortable about it sometimes. You might be ruffling family feathers. It's a difficult situation, isn't it? I think it's probably more a case of how you handle it than whether you make a claim. Do you know what I mean? It's the way in this, particularly in this area of law, it's about the way you handle the case rather than whether or not there's merit to your claim. Do you know what I mean? So anyway, you've decided that you want to instruct a lawyer or you want to bring your own claim, and you are thinking, well, problem is I've got a potential legal bill. Well, if you're instructing on your own, then that's okay. But even if you're on your own, you've got court fees. And also, the big bugbear, and this is the main topic for this particular vlog, you are facing having to pay the costs of your opponent if you lose. And let's say you issue proceedings, you may well have to, before anybody takes you seriously, before the executors of a will take you seriously. You can see how you might have racked up, or rather your opponent will have racked up, or may well rack up, a large legal bill instructing solicitors to fight you off. So now here's the strange thing about in these Inheritance Act cases. First of all, even if you've instructed a lawyer, because there's invariably a pot of money and everybody knows how much the estate is, a lot of lawyers are going to work on a no-win, no-fee basis, okay? now which means they only get paid if they win, and they take a share of the winnings, could be 25%, all depends on the risk and the amount of money at stake. In terms of court fees, that is often the problem in other areas where you're running no-win, no-fee litigation. But particularly in Inheritance Act claims, the procedure is just like an anomaly of the way the procedural law operates at the moment after April 2013. You don't have to pay a massive issue fee. In other areas of law, you have to pay a fee that can be 5%, typically 5% of the amount of the claim. So it could be in a 100 grand claim, and a will claim, an Inheritance Act claim, it could be a large amount of money you're claiming for, and you'll definitely be putting your case at its highest when you claim. So that could be 5% of a very large estate, which is a lot of money for people, particularly if they're financially challenged. But as I say, don't worry about that, particularly if you are in Inheritance Act claim territory. All right, now, so actually then the biggest, and it's interesting because in the case of one client, this was the obstacle, and I didn't know how to convince them otherwise, and this is partly the reason for making this vlog, and I'll be sending this video to this client that never was. And I think, and I found it very difficult to sort of allay their fears that they might not have to pay for their opponent's costs if they lost their claim. Now, it's important to understand that in any no-win, no-fee litigation where you're bringing an action, whether it's in wills, Inheritance Act territory or any other territory, commercial or personal injury or whatever, you can take out insurance, okay? And you pay the insurance. You may have to pay a little bit of upfront money, a premium of sorts, but you will pay most of the premium, hopefully, out of the winnings. So your winnings will be reduced. For argument's sake, just to give you an idea, 25%, maybe you'll have to part with 5% to the insurance company once you've won your claim. So that's the nature of professional indemnity insurance. I mean, that can cost some money. Sometimes the insurers will want you to write a check at the beginning of the case, as I say, for a fee. So, but here's the interesting thing, that even if you don't take out the insurance, I'm yet to come across a case. I'm not saying I'm vastly experienced, I'm not, but my colleague, one of my colleagues is more experienced than I am, and he's like, when I was talking to him, he was, it's funny, these cases, you never end up on the wrong end of a bill for the other side's legal costs. And I just thought I'd look at why that is. I think possibly, firstly, you're talking about a pot of money that belongs to nobody. So I think in that scenario, it's up for grabs, if you like. And I think in that scenario, there's not quite it's not quite as big a problem, because whoever is the executor, they will be using money that's not theirs. It's money from the pot, the estate, in order to pay out any claims. And even if your claim hasn't got a lot of merit, they're still going to make kind of some little low offer, which you can take it or leave it. So I think the fact that it's not the deceased, obviously, who's defending an action, it's the executive of the estate, and they're detached and independent. And I think that they will take a commercial view, and they'll just look at, well, we've got to shell out quite a lot of money to deal with a claim against the estate. Why not just try and settle for an agreed sum of money? I think the other reason is that it's often pretty clear that a claim is there. I mean, in all the cases that I've mentioned, you can see how it's kind of pretty clear that there's a claim. It's just really a case of between the executors of the estate and the person bringing the claim to sort of work forward to a compromise, as they argue, forward to a compromise of what the value is. And usually it's not necessarily that there's no claim or there is a claim. The law is reasonably clear, and in the Inheritance Act there are certain categories of people who can claim. so the law is reasonably clear. So usually, basically, it's simply a fight about the amount, the value of the claim, do you see? And I think that's probably another reason why it's never a situation where you end up having to pay your opponent's costs if you lose, because it's not really a black and white win or lose. It's usually a simple how much. So there it is. I probably will now discover I have a case land on my desk tomorrow that will, be one that clearly requires some after the event insurance, and we need to be very careful, because if we lose we may end up with a hefty stonking legal bill. But as I say, my experience so far, and I'm a lawyer, I've got to be careful that there is a caveat. Every case is different, and your case may be that different case. But certainly, to come back to this client that wasn't, because of the fear of having to pay for a large legal bill if they lost the claim, I would say don't be too worried. Don't be too worried. You're more as likely as not, what you're going to discover is it's not going to be hugely expensive to issue a claim. The lawyer's going to be prepared to go on a no-win, no-fee basis in return for a percentage, because there's a clear pot of money, so he knows that the estate can afford to pay out his 25%. And I think you'll invariably be dealing with executors who will be making a commercial decision and prefer to pay money out of the pot to you than to have to basically gobble up the money in the state with large legal fees. Okay, so there it is. I hope that helps throw some light, some clarity on the issue of having to pay your opponent's legal costs, and whether that's grounded in a real fear or whether it's just something of a fanciful one. If you feel you've got genuine merit and you've consulted with a lawyer and you fall into the criteria of someone who's entitled to claim against an estate after someone's died, then if you think you've been unfairly cut out, then don't be too fearful. Finally, I will just say that at the end of the day, it may be a case of how much, and you're probably wise to, it may be that you think you're entitled to a lot more. And so it might be that after you've issued the proceedings and you've got sort of somewhere down the track, it's become quite contentious at this point, it might be that then, you will need after the event insurance. But as I say, in terms of whether you're making a decision to begin the claim, to actually get out of bed and make the claim in the first instance, you shouldn't be overly fearful.